Hello, thanks for joining us. This is Mike Berger with NC Planning. I wanted to bring you a little bit of breaking news in the business and corporate law space. If you're familiar with employment contracts or HR matters in business and corporate, you've probably seen the term or come across the term non-compete or a non-competition agreement. That's one type of restrictive covenant. There are others, but on January 5th, 2023, just a few days ago, the Federal Trade Commission has proposed a new rule that would, in effect, ban non-compete agreements between employers and employees in most circumstances. And the second thing that this rule does is it requires employers to rescind any existing non-compete agreements with current and former workers. So this is pretty broad sweeping. This is a landmark rule. I don't believe this has been proposed before. And this announcement is really fresh on the heels one day after the Federal Trade Commission brought some lawsuits alleging that 3 different employers had non-compete agreements in place that violate the Federal Trade Commission Act. And so essentially what the Federal Trade Commission is sort of charged with doing is that they are policing or trying to ensure that companies don't participate in what they call unfair methods of competition. And the premise of this is really groundbreaking. It's really striking in the legal space. Most states have laws, statutes, and case law on the books that permit a framework and a structure for non-competition agreements to be in place. And what is now happening is that the Federal Trade Commission, under the current administration, is seeking to redefine or better articulate the unfairness, as their position is, around non-compete agreements. Essentially, they are saying or taking the position that, at least in the lawsuits that they have filed, that there are cases that they quote highlight how non-competes can block workers from securing higher wages and prevent businesses from being able to compete, end quote. They are essentially, the FTC is taking the position that they are, quote, committed to ensuring that workers have the freedom to seek higher wages and better working conditions without unfair restrictions by employers. These are from the Federal Trade Commission's website, an article on the lawsuits that they have filed. This is a developing area of the law now. We will continue to follow this at NC Planning. I will articulate what I think is typically the employer's position or the company's position when putting into place non-compete agreements. And that is that when a company, hires an employee to work for it, there are certain things that the employee is exposed to, and by signing a non-compete, they are agreeing effectively to, leave those things behind when they exit the company. The companies view this as a protective element of their businesses, of their proprietary information, their client information, etc. The FTC is taking the position that these are unreasonable restraints on trade, that these are unfair methods of competition, that these are things that stifle competition, and that under the FTC rules and regs and the Act, that is what the FTC is there to sort of protect against. There are a number of alternatives that are in play. I will say the proposed rule is very broad in the scope that it has set. It's about a 250-page rule, and it is seeking to kind of broadly ban all non-competes. There are some different alternatives, and we'll see how this plays out in the courts and as the rule gets sort of negotiated. But there could be wage limitations on the non-competes for, only employees earning below a certain threshold. I think $100,000 is a threshold that I saw in the rule. There might be certain other categories that they look at, but it is a developing story. We don't yet have a firm handle on exactly when the rule would go into effect, but right now this is a first step. There are some comments on the proposed rule that are due in about 60 days, or 60 days from the introduction, so 60 days from January 5th, so early March. Afterwards, the FTC can go ahead and finalize that rule based on input from the public. It's not a clear timeline as to how long it will take them to finalize that rule, but it's currently drafted in such a way that seems to indicate that it'll be about 180 days or 6 months worth of compliance window after the rule is finalized. In other words, they would set a date by which companies have to comply with the rule after the rule's been finalized and published. And so we think it's about, a window of another 240 days or so before it is proposed, final, comments have been collected, and then, put into effect for compliance. We'll see. Like I say, it's a developing situation. It's surely going to have a fair amount of buzz around it as these legal cases continue to work their way through the system. Again, there may be appeal rights from either party, depending on how it shakes out. And so appealing a case like this up to the United States Supreme Court, if that's where it goes, as this becomes possibly a federal question, a federal issue, will be interesting to see how the current panel of justices rule on this, because I think non-compete law has been a pretty friendly place for employers for a long time. I'm not sure that the current court is well positioned to rule more so in favor of the workers or the employees. And so it would be interesting to see how the current panel of SCOTUS would interpret this new broad sweeping restriction by the FTC. Again, more to come. We'll keep updating this as we get more information and as more commentary comes out around the proposed rule and around those lawsuits that the FTC has brought to try to strike down what they call unfair or overly restrictive non-competes. Again, land-breaking, law-changing rule here by the FTC, if it goes into effect, would have repercussions across virtually every industry, unless there are exceptions and curtailments made in that comments to the rule before the rule becomes final. So a lot to digest, a lot to think through, a lot to read through and work through in the coming days and weeks. But we will, at NC Planning, keep an eye on this and be available to discuss on future videos and content that we'll put out, and also available, to discuss with you one-on-one as desired. Again, I'm Mike Berger with NC Planning. I thank you for your time and tuning in, and we'll see you again soon.